everybody. Welcome back to the Law and Crime Network. I'm Michael Bryant. Defendant Charles Merritt talking to the police in one of the early interviews, and maybe the only time the jury is going to hear from this defendant. We just don't know yet. With me right now, I'm proud and happy to bring Steve Greenberg on. He is a criminal defense attorney. And Steve, thank you first of all for joining me. I appreciate the time.
From very, very cold Chicago.
Come on. How bad could it be? What is it?
3 below.
Oh, okay, that's bad.
That's
and
cold.
It's probably coming this way, so thanks a lot.
I hope so.
Let me ask you this. We just heard a little bit from the defendant via police interview. We don't know whether he's going to testify. How important is it for you as a defense attorney to do what you can with this interview? Some of it's going to be bad, some of it's going to be good, but if you haven't figured out yet whether your defendant is going to testify, what is the importance of this interview for you from the defense perspective?
Well, you have to highlight the positive, like you said, and try and minimize the negative. The problem that I've had in my experience is that when you've got a real serious case like this and you've got some DNA, for instance, was found on the bumper of the family car by the desert, by the border with Mexico and so forth, your defendant almost has to testify because he has to explain things. He has to say, I was in that car. Jurors want to hear from defendants, even though they're told they don't have to testify.
Yeah, and that would be critical. If there's something else, I don't know if that's enough to make me want to throw my guy in the stand just to make sure you can explain away DNA on the car. Because remember, in closing, you could clearly argue that, hey, they were buddies. They did stuff together for work, outside of work. Not surprising to find his DNA in the family car. But you're right. He could get on the stand and say exactly that and maybe reinforce it. But, of course, if he does, he's going to be opening up all kinds of doors to other testimony that might not be so pleasant, right?
But you've got other things that he needs to cover. You've got the communications, the emails, the text messages. He's going to have to explain it. So even though he doesn't have to testify, he has a right not to testify in a case like this. And you said it's going to take a couple of months. I can't imagine what they're going to do for a couple of months on this. It seems like there's too many open ends that he's going to have to explain. Yeah,
and part of the time is that, it's 4 murders, so they have to plod through all of the details and facts to lay out the case for each of those murders. So that really quadruples even a, quote, routine murder case. Hey, Steve, I'm going to mark you down here for defendant will testify. I've got you down for that. And just in case that doesn't happen, we have more of his interview with the police. He's now talking a little bit more about maybe somebody else that we've heard about might have done this. Dan Cavanaugh, the name comes up in this interview with the police.
I was building every waterfall all myself, and I was dying. That's what gave me a heart attack, actually. It was because we got really busy last year, and we were just really cranking. What's Dan's role? Dan was the witness. He actually, to the best of my knowledge, he owns part of Earth Inspired Products. Joseph was buying him off. Him and Joseph kind of had they weren't real happy together. Or Joseph wasn't real happy having to pay him so much. Do you know what he paid? I have no clue. Joseph didn't tell me a whole lot about it. And you, Joe, and Dan all lived in the same apartment at one time at the beach? Oh, no, I've never met him. Oh, you've never met him? No, I've never met Dan. The first time I talked to Dan was a week ago or a little less, or when all of this started. Dan called me and said, hey, what are we going to do? I said, I don't know. I don't have any access to, Joseph's emails. I don't have any access to any of this. I can't help him. That's the extent that I know about Dan. As far as my role, I met Joseph. He actually contacted me to start building custom waterfalls 2.5, 3 years ago. And I started building his custom waterfalls, and I'm still doing it now, today. And so I don't have really anything to do with Earth Inspired Products. I have my own, I manufacture waterfalls. I had my own line of waterfalls, my own, everything. Joseph got me more deeply into the custom ones. He does all the sales. Basically, I mean, yeah, we're partners in getting water calls done, and and we make money. But
so you hear that? We hear Dan Kavanaugh's name, and we hear $200,000 owed to him by Joseph McStay, and he's being paid a little here and a little there. Is Mr. Merritt so clever that he is already in this early police interview trying to throw some shade on another guy and create a motive for somebody else to kill the McStay family? With me, Steve Greenberg, criminal defense attorney. Two things, Steve. First of all, what do you think about my theory? And number two, what do you think about the defendant's demeanor in this interview?
Well, his demeanor to me is fine. It's very matter of fact. This wasn't a loved one. This was someone he was in business with. So it was a business associate. I wouldn't expect him to be completely distraught, and it's many months later. And it's interesting that he's bringing up this Kavanaugh story so early on, because Kavanaugh was actually raiding the bank account of Mr. McStay shortly after McStay disappeared. And there's kind of an explanation given by Kavanaugh to that, but it was something he hadn't done before. It's weird that he would think that if a guy's just missing, that you can take money out of his bank account.
Yeah, that is kind of a step you might not want to take, especially when the killers are still out there somewhere. It might show that you're a little more involved than maybe you should be. But right, as you said, pretty interesting that Merritt would throw his name out there and lay out a motive effectively in that early investigation. So we'll see as this case develops, where
and it would pan out.
Yeah, exactly.
And it would pan out.
Exactly. And we'll see. The numbers are critical here. He mentioned 200,000. We haven't heard or seen the evidence to suggest numbers that large. But hey, it's early on. Day 11 just finished. We are going to come back with more of the Merritt case out in San Bernardino, California, the McStay family massacre, and we will come back to Law and Crime after this. Heatherly, kind of like a Julie Christie novel, some sort of very special name. She's a crime scene specialist. She was at the scene helping uncover the gruesome details and the bodies of the victims in this case against Charles Merritt. Joining me is Steve Greenberg. Steve, let me ask you a couple questions about the location. First of all, how important is it for the jury to kind of understand exactly where it is and how this all unfolded? And number two, a jury site visit would not surprise me. How would you handle that as a defense attorney?
Couple of things about where the bodies are found. It's out in the desert. It's fairly remote. It took a long time before someone found it. You like to think that when they did the initial recovery, they took pretty good video and photographs, which would give an accurate impression of what the scene was like. I see some are there. And then I don't know why you would take the jury out. I know that they like to take the jury out, but whatever was there at the time is gone. It's been preserved in that they recovered everything, but after they finish doing their recovery, doing their forensic workup of the area, the evidence technicians and so forth, they leave the area to the elements, and who knows what's happened since then. So the scene is not going to look the same. You would
object to a site visit then, am I getting that right?
Yeah, I would object to a site visit. The only time I ever like a site visit is when someone says, they were 3 blocks away and they could make my client's face out clearly in the dark of night.
And maybe the events are less remote in time to the finding of the bodies. Now, a lot of time has passed, not just from the crimes, but even from the finding of the bodies, it's been some time.
Right, and it's the desert, the shifting sands. They use those words for a reason.
Yeah, and that, unfortunately, is what ultimately led to the recovery of the bodies out there. They also found out there what they believe to be the murder weapon, which is a 3-pound, what they're calling a sledgehammer. I have one here that is similar. This is a 3-pound sledge. It's really called a drilling hammer, and it's used by the manufacturer's description to when you need heavy hitting. That's what this is for, when you have a heavy hitting project. If a normal hammer is a pound, this is about 3 pounds, so it's noticeably heavier. This is not the hammer that Grandma uses to hang those pictures over the plastic-lined couch. This is serious. This is a serious hammer. On the other hand, it's not very easy to wield. So, what can you do with that, Steve, if anything, to help your guy in terms of what kind of crime this might have been and how this weapon was used?
Well, a couple of things. First of all, there's really no wounds on him that anyone reports in the days after the disappearance. So if you've got a hammer of that length, you would think that someone could reach out. You know, you're not, like you said, full-size sledgehammer where someone can't get at your arms or something like that. You expect maybe to see some kind of wounds. Also, how do you kill 3 or 4 people with that size hammer? No one escapes, no screaming, nothing like that. I don't know how you could accomplish that so quickly with a hammer.
Yeah, I was thinking about that. You know, it is not like a gun where you can go bang, 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 and 4 people are gone.
Right.
You know, the mechanics of using a weapon like this, not only does it take time, you know, just the act, but you have other people, you would think, in the area, either watching or hearing, giving them time to, you know, react defensively. I don't know that we'll ever know exactly how it might have played out by whomever did it. But the fact that this was the weapon seems to me, again, as I mentioned earlier about the extension cord being kind of a weapon of convenience and just happened to be there, maybe the hammer was a weapon of convenience as well. It was there, and the defendant or somebody decided to use it.
But if you lose control, if all of a sudden you get so angry that you commit a murder, it's unlikely that you're going to kill the business partner, the wife, and the kids. There's something really just out of sort with this.
Thanks, Steve. We're going to take a quick break, guys. We will be back with more on the Merritt case on Law and Crime. Welcome back to the Law and Crime Network. I'm Michael Bryant. We are covering 2 cases, one in Ohio, one in California. The Ohio case ended in a guilty verdict, and we're going to look at some of the reasons that happened. We've got some incredible testimony and some interesting courtroom antics that I think you'll enjoy. We're also out in California for the Charles Merritt case for the murder of the 4 McStay family members. But before we get to either of those cases, let's see what else is going on with the other top crime stories.
On Law&Crime.com and across the country. The city of Evanston, Illinois is set to pay $1.24 million to a PhD student who was struck by police at least 10 times for, quote, stealing his own car. The incident occurred when a bystander called 911 on Dr. Lawrence Crosby, claiming someone was trying to break into a vehicle. Dashcam video shows Dr. Crosby being tackled by a number of police officers after exiting his vehicle with his hands in the air.
On the ground! On the ground!
Yes, this is my vehicle, sir. I was trying to fix something on the roof. Okay. I have evidence to that end.
Well, when we tell you to get down, you got to get down.
Yes,
man.
sir. I understand.
Okay.
Crosby was initially charged with disobeying police and resisting arrest, but was acquitted of all charges. He filed the now successful lawsuit a year after the incident. Harvey Weinstein reported to court today to formally sign off on changing his legal team. 2 of the disgraced mogul's new dream team include Ronald Sullivan Jr. and Jose Baez, who represented Casey Anthony. The pair also formerly represented Rose McGowan, one of Weinstein's most outspoken critics and accusers, when she faced drug charges in Virginia. Baez, Sullivan, Pamela Mackey, and Duncan Levin replaced Weinstein's former attorney, Benjamin Brafman. The home where Colorado father Chris Watts murdered his wife and 2 daughters will be auctioned off this spring. Watts entered a guilty plea to multiple murder charges for the death of his pregnant wife Shannon, his daughters Bella and Celeste, and Shannon's unborn child in November. He's now serving multiple life sentences for the crime. Prosecutors claim that Watts killed his family in the home and drove their bodies to property his company owned. He buried his wife in a shallow grave and dumped his daughters in an oil tank. The auction is set for April 17th. For Law and Crime, I'm Rachel.
And thank you, Rachel. There is a lot going on, and we're happy to cover it for you here at the Law and Crime Network. We are following the California versus Charles Merritt case, the case against the business partner allegedly having killed his business partner and his family over money. With me is Steve Greenberg. Steve, we're going to hear more of the interview with the defendant here, and I think this part of the interview makes it very important what you say as a defendant or a suspect or a person of interest when talking to the police. Something as simple as the tense in which you refer to a victim, it can be devastating.
Say nothing. Say nothing.
Say nothing. That's the short answer. Say nothing. Yeah, well, you know, sometimes suspects, persons of interest, they're very smart. They know how to outsmart the cops. And they can use this, they think, as an opportunity to just show the authorities how smart they are.
Well, you know, the old saying about organized crime, if it was so organized, they wouldn't get caught. The same is true of criminal defendants. So you may think you're outsmarting the cops, but the only reason someone is now hearing what you said is because someone thinks you didn't outsmart them and you got charged. So you're better off saying nothing.
Yeah, and here comes a perfect example of that. This, again, is the defendant, Charles Merritt, talking to the police, and he's referencing his friend who is officially just missing. Listen to this.
Any enemies. Everybody loves Joseph. Everybody. He has no financial problems that I know of. I mean, him and I, you know, I mean, things were tight over the last few months because of the economy, but stuff has been, over the last couple of months, things have started picking up, and everything was looking really promising, and Joseph didn't have that much problem financially anyway. I know for sure that his bill and their loss, if there's something wrong, or they're not coming back, how does that affect you? My business is done. Our entire business. You have nothing to gain by the loss. No. You have nothing to do with any, whether it was them going somewhere you didn't help participate in. No, not in any way, shape, or form. Nothing to do with the disappearance, whether it's good or bad. Absolutely not. No. We have. I mean, I don't know of anybody that has anything to gain by Joseph being gone. I think everybody that I know has everything to lose. Everything. This business stems almost solely around Joseph. He does all of the sales. You know, Dan's trying to send me some emails and try to, need to try to salvage some of the jobs that are trying to send stuff back, because if they can't get hold of Joseph, they're pissed off, things like that, and projects that people are calling in for saying, we're ready to do them, and you get hold of us, and I'm trying to call them and trying to, but I can't do it.
So there's Charles Merritt talking to the cops, brings up Dan Kavanaugh's name again, every chance he gets. Throw in the Dan Kavanaugh reference. With me from Chicago, Steve Greenberg, criminal defense attorney. So, of course, if it were your client, you had already spoken to him ahead of time, they would not be having this conversation. They would be saying nothing. But too bad, you've just inherited this client. The interview's done. What do you do to try to diffuse what he may have said in the interview?
As much as you can, you try and prove that what he said is not factually correct. You try and convince the jurors that, look, this is someone who's just trying to help the police out as best he can. His friend is missing. I don't know from what's been shown how long he had been there. A lot of times you can show that he's been worn down. He's been, police are known to hold people for a day or two while they're interrogating them. They're held in cells, very little sleep. They come and they wake him up at 2 in the morning and start interviewing him again. You got to see what he looks like, all of that. There's all sorts of different ways to attack him, but ultimately, unfortunately, people don't believe that individuals confess to things that they didn't do, which is factually correct. Individuals wrongly confess all the time.
That's good, Steve. I got the picture of Gitmo and the way they were treating this guy before they, even arrested him. So you're right. I mean, the visual reference that this jury is not getting is critical. And all they have is the defendant sitting at the table while this audio is playing, and there is limited information you can get from just hearing that audio. I am glad that it is, at least it is something you can hear. Sometimes the audio that comes through the court system there. for the poor jurors. They can hardly hear anything. Yeah, Steve.
Yeah, I'm sorry. Why isn't there any video? You know, that's something that I find quite odd. Years ago, we used to always say here in Illinois, look, they could have recorded it, they didn't. They could have videoed it, they didn't. You know, and you go through this ridiculous cross. Do you have a video camera? Do you have a camcorder? You know, you use it with your kids, all that kind of stuff. But now it's mandatory here in Illinois to video interrogations. And I'm surprised that there's no video of this in such a serious case.
Well, you know, California's going broke, Steve, so they can't afford video. This is San Bernardino County. It's a kind of a...
Whip out your iPhone.
I'm with you. And I think it probably, well, I don't know, would have been helpful for either side. I don't know. It just gives the jury something more to look at, to chew on. For now, though, we've got audio, and we're going to listen to more of the audio interview between the authorities and Charles Merritt.
I try not to think about that, actually. Mikey and his mom keep saying, you know, things like that, but, you know, I don't know of anybody that's hurt Joseph, or two of the kids for that matter. So,
do you have any knowledge or information that indicates to you that it did?
no.
Okay. The reason I asked is because you have used the past tense about Joe a couple times. And you said Joe was. Typically people don't do that when people are alive. Any explanation as to why you may have done that?
No, not really. I just, no.
Do you understand what I'm asking?
Of course. No, of course. I completely understand. But no, I never really even thought of him as possibly being, well, I can't say I haven't thought of him as possibly being dead, but I have, but I don't like to think of it that way, of course. So no.
It's interesting because, you know, we deal with families and friends and people all the time. And oftentimes they'll notify them that their loved one is dead, but they will still use the present tense because it really hasn't set in. And that's why I'm asking you to use the past tense a couple times, which is really unusual.
Yeah. I have no idea. You know, I'm not sure what I used past tense in context with, but I have no idea why.
You said Joe was my best friend.
Oh. I did.
You did.
And I don't know why.
Okay. Did you guys have a falling out at all?
Never.
Okay, so it would be like he was my best friend and now we're just...
No, absolutely not.
Okay.
Joseph is...
Okay, so what do you think happened to these guys?
I really have, I mean, I haven't been able to form any real explanation as to why Joseph would just disappear.
Charles Merritt in his interview with the police in the case of California versus Charles Merritt. And my guest Steve Greenberg is with me. Just to your point, Steve, I would have loved to have seen his face when the officer investigating said, well, you know, you said was your friend, past tense. There was kind of a pause, but boy, if we could have seen how he reacted to that, might have been very interesting.
Right. I just don't know why they wouldn't video these interviews at all. And even the audio, maybe some of it's because we're replaying it, but it's extremely difficult to catch every word that he's saying. Now, I can tell you that watching the camera angle here, although it's from behind, he does seem to be upset while he's listening to the audio. I don't know if that's because he's upset because he's hearing himself say things he shouldn't have said, or he's upset because his friend is gone.
Yeah, I mean, he's a very active defendant. He's writing. He's talking to his attorneys. In this case, he's kind of got his head in his hands. But you're right. Is that because he is bringing back some memories of a horrible time, or because he's saying, boy, I stepped in that one? You know, it's hard to tell. So this interview Again, at this point, the only thing we have heard from the defendant, you believe he's going to testify, and I can't wait. I hope you're right. But from the juror's perspective, in a case that's going to play out over time, what do you do as a defense attorney maybe to water down the importance of this interview if, you know, now 2 months down the road, 3 months down the road, you're coming to closing argument?
You got to see what else develops between now and then. I think that unfortunately they're playing it at the beginning, which leads me to believe that the prosecution thinks it's a fairly devastating interview because now they're going to bore the jurors with forensics and, you know, autopsies and pictures and all that kind of stuff. So this must be, when you're a prosecutor, you always try and start off on a real high note because the studies have shown that even though they're supposed to keep an open mind, jurors do form impressions very early on, sometimes during the opening statements.
Yeah, and then they start to kind of drift off during the course of the trial, and, you know, you want to make your points early, and I guarantee if I'm doing the closing argument, this has a bullet point by it. This past tense reference is huge. Thank you, Steve. Steve's going to stay with me. We're going to come back here in just a moment. We're going to move to the center of the country, to Ohio, for the case against Claudia Herrig. Crazy case. Defendant did take the stand there. Steve, you're right about the defendant in that case. We'll be back for the Law&Crime Network. Back to the Law&Crime Network. I'm Michael Bryant. We just left the California case against Mr. Merritt, and now we're going to, that case, by the way, will be picking up again live on Monday. They are dark on Fridays for procedural issues. It's a long trial. They need to plan these things. So we're going to move now to Ohio. This is the case against Claudia Herrig. This is a wife who killed her husband. This was never a whodunit. It was kind of a how she done it and why she done it. The defense position was, hey, she was distraught over the husband not wanting the baby she was pregnant with first, and then other issues between them that led her to feel like this, you know, this just isn't worth living. So she buys a gun a couple of days before the shooting. She goes and tries it out at a gun range. She gets a laser scope on it, of course, because when you're somehow that is, I guess, going to help in the suicide attempts. So she's distraught. She's going to kill herself, but somewhere in the process of trying to kill herself, she gets mad at her husband, Major Carl Herrig. And bottom line is, he said, hey, if you're going to kill yourself, fine. Just don't spill blood on my stuff. So go down to the basement where, you know, any mess you make is going to be contained. And according to the defendant, she snapped. She snapped, killed her husband, shot at him 5 times, hit him 3 times. And this is not a case then of whodunit. It's just, is it aggravated murder as charged, meaning she was out to kill him, or was it a crime of passion, heat of passion? As we know, let's step into the Law&Crime classroom for just a minute here. Heat of passion is a mitigated murder, meaning it's a less serious level of murder and therefore less penalty for that murder. So if she's convicted of aggravated murder, then it's you know, at least 30 years. The judge has a lot of latitude in how he sentences. And in Ohio, you can get death, but not in this particular case. That was related to the extradition agreement. We'll get into all of that. Before we do, let's just go right to the chase here. Did the jury believe she was out of her mind, passion, killing, or did she, you know, plan this thing out and intentionally, with aggravation, murder her husband? Here is the verdict.
Paneled and sworn or affirmed, find the defendant, Claudia C. Herrig, guilty of aggravated murder as she stands charged in the first count of the indictment, dated this date, signed by all 12 jurors. As to the specification, we, the jury, in this case duly impaneled and sworn or affirmed, find the defendant, Claudia C. Herrig, did, at the time of committing aggravated murder, have a firearm on or about her person under her control, brandished the firearm, indicated that she possessed it or used it to facilitate the offense, again dated this date and signed by all 12 jurors. Ms. Fowler, did I properly read the verdict of your jury? Anything further from the state?
No, Your Honor.
Anything further from the defendant?
No, Your Honor.
All right, ladies and gentlemen of the jury.
So apparently the jury not buying the idea that this woman, Claudia Herrig, was so upset at something her husband said that she turned from suicidal to passionate homicidal. They found her guilty of aggravated murder and is to be sentenced, we believe, on February 8th. At that point, the details of the extradition agreement might come to light. They may limit how much time she can get as part of an agreement when Brazil sent her back to the U.S. Steve Greenberg is with me, a defense attorney from Chicago. Crazy case with a surprising result, or what you expected?
Well, you know, there were some facts in there that didn't really fly. She's this distraught, crazy lady. She's going to so upset she's going to kill herself, and then when he says, go ahead and do it, instead of killing herself, she kills him. That's kind of a nonsensical story. Then you throw in the fact that she did buy the laser sight for the gun. She says she buys a gun to kill herself. Well, obviously, you can't use a laser sight on yourself. It will be interesting to see, however, the extradition agreement and how that's phrased and what penalty she's actually looking at.
It is, and again, we should see that on or before February 8th, and of course we'll have that for you here at the Law and Crime Network. Let's now take a look at the defendant's testimony. She took the stand, long, drawn out, dramatic. Let's go to the courtroom.
And so he opens the door from the bedroom and you're standing there with a gun to your head?
Yes.
Okay. And what happens next?
When he opened the door, he saw that he didn't have much of a reaction. He just stared at me for a while, 5, 10 seconds. He didn't do a thing. He kept staring at me, kept staring at him, and I was crying. I was crying, and he didn't have any emotions to his face. Nothing. I couldn't read him. No emotion. All of a sudden, he grabbed me. He grabbed my wrist and my throat, and he grabbed me, and he just grabbed me. And then when he was done grabbing me, he just pushed me. He pushed me, and I fell back, and I hit a wall, or there was a bedroom in the middle. I hit that wall, the door frame in that area. I hit my back, my head, and I just stayed there the first time, and he died instantly. And he just fell, his body just fell like this. And as he was going down, I think his right foot was still up in the air. And that's when it buckled and he lost his right shoe. And his body just went boom. Since he didn't make that sound, didn't move anymore, I know he died from the first shot. And then
well, let's stop right there. So you were at the top of the steps, and you shot him as he was walking down the steps?
Yes.
And you shot him once?
I remember shooting the first time very vividly. I was on top of the stairs.
Okay. And you think that shot killed him?
I know it did.
Okay. And why did you think that shot killed him?
Because he made no sound ever of being wounded, of hurting. And I saw that he never moved. The position that he felt, the position that he fell on the floor, he never moved from that position.
And so he fell on the floor at the bottom of the steps?
He did.
Claudia Herrig, she's a talker, but I'm telling you, as the defendant, I'm waiting for her to give me something to believe about the passion of the killing. You know, something that suggests she snapped and then it happened. I don't hear that. The other thing, and Rachel Stockman and her guest were talking about this earlier in the afternoon, the likability factor. I wrote that in big notes when I saw her yesterday. She's not likable. Okay, now, likability doesn't affect whether you're guilty or not guilty. You know, I met and interviewed a guy you may have heard about, kind of involved in some murders out in Brentwood. He was acquitted, but in my opinion, nicest killer I've ever met. So that's not necessarily determinative of guilt or innocence. So tell me, Steve Greenberg, you know, how important is it, if you're going to put your client on the stand as a defendant, that people might like him?
Well, as I'm listening to that, I'm thinking she killed him because she was mad. I'm not feeling any passion. She talks about him grabbing her and pushing her back. I'm not feeling any fear. And so if you feel like she's a cold-blooded killer, she's not going to be likable. There's no emotion from her. She talks about killing herself and killing him and apparently killing a child, but she doesn't do any of it. I don't know why, what her explanation is for that. But I totally agree with you. She is not likable at all.
Yeah, and her story is even her story is a little convoluted about the mechanics of what happened and how it happened and where it happened.
And too detailed. Too detailed.
Yeah, almost like
it looked like she's making it up.
Yeah,
as
like
she goes along.
she wrote the story and now she's sticking to the script, maybe.
Right, right. It looks to me like she's making it up. Well, you know, he reached and he grabbed and he pushed and I fell and it was kind of a door, but it wasn't a door. It was a wall. I just wasn't feeling any of it.
Yeah, and then she talks about falling backward and they continued a conversation and they talked a little more and then she decided, obviously the jury wasn't buying it. We're going to come back and get further into this case and kind of see exactly what the jury saw that led them to convict this woman. More with this case out of Ohio. Let me come right back. Agent Sano of the FBI helped bring the defendant back from Brazil. Good witness. He knows, hey, should I stop? I don't want to offer anything I shouldn't. Let me bring Steve Greenberg into the Law and Crime classroom here, Steve. Why did they not have to Mirandize this on the plane?
Well, I actually think they probably should have Mirandized her on the plane because she was in custody, even if they weren't going to interrogate her. I don't think that Miranda just applies when you're going to be interrogated, and I think they were told not to because the prosecutors were hoping that she would voluntarily make statements, so they didn't want to advise her. Remember, this is someone who is a foreign national, so they didn't want to let her know her rights in case she wasn't aware of them. So I actually think that was a sort of a very fine line trick. I'm sure that the defense tried unsuccessfully to suppress the statement.
Yeah, no
but
doubt.
I think that anytime they take someone into custody, they should Mirandize them.
Yeah, and I think it's safe to say when you're on a plane returning from a foreign country and there are two law enforcement officers with you, you pretty much feel in custody. Pretty safe bet you're not leaving, right? Okay, we're going to come back with the closing arguments from each side in this case and see how persuasive they might have been to get to that conviction when we come back with more on the Claudia Herrig case here on the Law and Crime Network. Defense attorney tried to do the best he can to get his client the best sentence possible, because if he can convince the jury that this was a passion killing, well, the penalty is far less than aggravated murder. Steve Greenberg, you know, these closings involved a lot of argument, as they should, but a lot of objections. Do you make it a practice of objection during your opponent's closing argument?
Well, you don't want to object because it seems like you're trying to hide something. Sometimes, though, you end up with a opponent who just doesn't follow the rules, and you find yourself having to make the speaking objections. I found that the grayer I've gotten, the less the jury has looked negatively on my objections. So they now think I know what I'm talking about.
There's that fine line between, you know, zealous representation and annoyance, right?
Right. But, you know, someone should, the rules for closing argument are pretty broad. You can say almost anything in closing argument. So there's really no purpose in objecting. At best, the judge is going to say, jurors heard the evidence. Every once in a while, you'll get a stretch on it where someone will just have a zinger and you just can't recall any testimony on that. And you'll get lucky and the judge will say, that wasn't the testimony. That could undermine the opponent's credibility with the jury and be quite helpful.
Right.
In this particular argument,
you can't misstate the testimony,
can't misstate.
But you can use any evidence or inferences drawn from that to come up with an argument. That's why it's called an argument. So in this case, when the defense counsel kept breaking in and disrupting, you know, I think there was a point where they got beyond the zealous representation and maybe kind of annoyed the jury.
They may have, you know, and that's the thing about these arguments is I actually like, maybe I'm just biased, but I like the defense attorney's delivery and the way he's coming across, and it's folksy and it's likable and it's believable. You know, when he says, hey, if she went in the gun shop and said, I want to get a gun to blow my brains out, they wouldn't sell her a gun. That makes perfect sense.
That's right. Hey, Steve, I appreciate you being with me this afternoon. Steve Greenberg from Chicago, criminal defense attorney. He's going to hang around and talk with Aaron Keller during the daily debrief coming up at 5 o'clock. So, Steve, thank you very much. I appreciate it. Great job.
Thank you. Enjoy the coming cold.
Thanks. So don't forget that we will be back in the Merritt case on Monday. We'll pick up there where we left off, which was examining the findings from the desert. And we'll have other crimes and trials to bring you as the week progresses. Don't forget that coming up at 5, just a few minutes from now, Aaron Keller will have the daily debrief. If you've missed anything during the course of the day, Aaron will have everything figured out for you and hit the high points. And also, if you missed it last night at 7, Brian Ross Investigates. It was the premiere edition of the program. It's on again tonight at 5:30. They investigate how Saudi dictators use the latest technology to track down those who dare to speak out against them. These are the same social media platforms and devices that have given a voice to dissidents, and now it's being used to crush them, to imprison them, and to kill them. So make sure you check that out at 5:30 after the daily debrief. That's going to do it for me, Michael Bryant. I will see you sometime next week. We'll get into the McStay story. But in the meantime, Aaron Keller's coming up with the daily debrief. And that's it for me now. See you next time on the Law and Crime Network.